Chairman Ekal Karanji Branch and Chairman Sadar Branch. It's my proud privilege to be here amongst a wide spectrum of audience to be giving a talk on something slightly offbeat for practicing chartered accountants. I won't say totally offbeat, but slightly offbeat about succession planning. I would not say that I'm an expert in succession planning because it involves a lot of law other than CA, but over a period of time, chartered accountants can give very good inputs on how to plan your estate, how to plan your assets, etc. And as we all know, just before the budget, practically every year we hear talks of estate duty coming back and what is the best way to plan your estate, etc., etc. So with this, I'm just paid an attempt to make my lecture to the extent interesting as much as possible, knowing it's post-lunch. So not going too much into heavy topics, but making things a little simpler and easy to understand because some of this we already know. We know most of the things, but how to put it in one go, under one roof is what is my attempt. Because we have been reading a lot of things about, for example, HUF, trust, wills, but what I have done is segregated them into compartments so that we can read things about or discuss things about, for example, will, trust, HUF, etc. in under one compartment, so it's easy to go. So without So this is my topic. I'm going to discuss taxation with a little bit of other related laws which are important for us to understand. So first let's understand what is succession planning. So this is the index for topic. First let's understand what is succession, just to understand what is succession. And then succession we can have in different ways, either by wills, family settlement, or forming private trust, either under wills or otherwise. And I've also touched upon Hindu undivided family, partly just flavor of what is HUF is, because in Indian customs, Indian families, HUF still occupy a very important role. And it's important to know what are the tax provisions which touch upon HUF. So I've also attempted to taken basic things about HUF in my talk. So let's first understand what is succession. Now succession is not defined under any law in India. If you see, it's nowhere defined. It's just derived its meaning with the legal provisions or legal cases or English cases. So judicial dictionaries, how they define succession, let's understand. So IS dictionary says it is devolution of rules to property under the law of descent and distribution, and the right by which one set of men may, by succeeding another set, acquire property in all goods, movables, etc. And there is a case which simply says that it means the fact of the transmission of rights, obligation and charges of a deceased person to his heir or being. Basically, succession is about what's going to happen after my death to my estate, my assets, my liability, etc. And then another simple meaning which the dictionary says is the process by which a person or persons become entitled to the interest of deceased person by way of inheritance. So, and it is always governed by personal law. I'll just touch upon those basic provisions of personal law. So succession also is governed by personal law in India because we have different personal laws in India. So it's about succeeding a deceased person's estate, and what are the laws and what are the tax provisions. So the most common thing and which we are familiar with wills. In legal language it's called testamentary succession. When a person makes a will, it's called testamentary succession. If he doesn't, if there is no will, it's called intestate succession. Now will, these provisions about will are extensively discussed under Indian Succession Act. So just to understand basic terms, we have to refer to Indian Succession Act. So I've taken up some important definitions which makes makes us things easy for us to understand. What is will? Will is a legal declaration of the intention of the testator. Testator is a person who makes a will. So it's his legal declaration of what he intends to do to his property after his death. That's called will. Will is a declaration. The second one is codicil. As you know, codicil is an amendment to a will. So, for example, if I made a will and after a few years I want to make some changes to certain clauses, I need not make a fresh will under law. I can just make a codicil saying that I am amending certain clauses of the will. So that's what is called codicil. And there is a fine difference between administrator and an executor. Administrator versus administrator. Administrator is a person who is appointed by the competent authority. So it's when a person dies and there is no executor or there are certain conditions when the government appoints administrator. That person is called administrator. And executor, as we all know, is the person who is going to execute the will of the deceased. So that person is executor. So Indian Succession Act defines him as the person to whom the testator has confided in his will that you are going to be the executor of my will and you will carry out my wishes. So that's execution. Probate. Another important provision I thought though tax provisions don't touch upon, we should know what is a probate. Probate is basically a certified copy of the will, which is certified by the Court of Competent Jurisdiction. Now, all states do not require a probate. It's only certain states in India which have continued with those laws of some presidency laws, they require probate. Mumbai, Maharashtra being one of them, Madras and Calcutta. Those cases require a probate. All states do not require probating a will, getting a certification done by the High Court. Then there are two important provisions about how succession to immovable and movable property of a deceased will take place. So, as per Indian Succession Act, immovable property succession is governed by laws in India. So even if a person is domiciled anywhere, deceased may be domiciled in London, wherever, but if the immovable property is in India, there is a law in India which will govern. And for movable property, it will be the law of the country where he was domiciled. So these two things, just for overall understanding, we should know, and these are all from Indian Succession Act. Another important thing about the will is that will is not a technical document, it's not a legal document as I mentioned, it is just a declaration of what the testator intends to do with his estate. So it could be a simple statement, I wish my assets to be dealt with as under in a clear term. So there is no legal language required, it's just a declaration of your intestate. But the language should be very clear and it should not be ambiguous. So because I am declaring and I am to say do this, do not do this, etc. No leaving no ambiguity. And another thing about will, when a will is prepared on a paper, you can prepare on a plain paper, it is not necessary to register it. You may register under the Registration Act, but it's not mandatory. For safety, a lot of people register it. But for will to be correct and effective, it has to be signed by two witnesses in presence of the testator. So they have to be two witnesses with their complete address, names, etc. So two witnesses, it could be on plain paper. You can, as I said, will can be modified as many times as one wants. And every time you modify, either you can make a fresh will or you make a codicil. But every time, suppose you make a codicil, it will replace certain parts of your old will, whereas the new will substitute the old will. An important thing we often read in media and business news items that often wills are contested because what is required, sometimes people contest that so-and-so will was done, it was under coercion that will was done, the person was not of sound mind, etc. So in fact there is a provision of law which says that will can be made only when a person is of sound mind and good health. So he